Good afternoon, everybody, and welcome to this issue of the Bonavero Discussion Group. My name is Kate O'Regan, and I'm the director of the Bonavero Institute of Human Rights at the University of Oxford. And this discussion group is an opportunity to discuss contemporary issues in human rights. And as I was saying to the presenter and the discussant before we started, one of the wonderful things about today's discussion is that it's a good news story in many ways about human rights. Our speakers are firstly Professor Alan Miller, who's the independent co-chair of the Scottish National Task Force for Human Rights Leadership and a professor of practice in human rights law at the University of Strathclyde in Glasgow, and Dr. Hayley Hooper, who is herself a Glaswegian and who is a fellow at Harris Manchester College. So Professor Miller has been co-chair of the Scottish National Task Force on Human Rights Leadership, and that task force has recently produced a report and a draft bill in order to prepare a draft bill in relation to embedding and deepening human rights in government in Scotland. And so it has been a very interesting process and a very thoughtful process. And we're really delighted to have him here today to tell us about it and to describe not only what the task force has found and recommended, but also how he sees the way forward. He, as usual, will speak for about 25 or 30 minutes, followed by Hayley Hooper, who'll speak for 10 to 15, and then we'll take questions from the floor. The Q&A button is at the foot of your screen on the right-hand side, so please feel free to put in any questions that you have there. Right, Alan, a warm welcome. Thank you very much for being here, and we really look forward to hearing what you have to say.
Thanks very much, Kate, and good afternoon to everyone. And thanks to everyone at the Bonavero for hosting this event and inviting me to make a presentation, but also many more thanks for the contribution to this process that the Bonavero Institute has made. The task force asked for advice from the Institute, which they were very generous in providing, and it very significantly contributed to the work of the task force. So I would like to record the gratitude of the task force and of the government, which was very pleased to get the support. The report from the Bonavero Institute, I see it anyway as setting our process with 5 tests, 5 principles or challenges that a country attempting to do what we are attempting to do should bear in mind. I would like to think that we have met these tests, but others will be the judge of that, and not least Kate herself, I'm sure, and Manuel and Martin, who collaborated with her in the report. So in the time that I have, what I would like to do is perhaps try to explain 3 things about mapping the human rights way forward in Scotland, recognizing that possibly quite few of you will have much familiarity before now with Scotland and with the human rights context there. So the first thing I would like to do is to share with you something of the context, so why this initiative has been undertaken in Scotland. And then secondly, I'd like to share with you the content, what will be the essential features of the new statutory human rights framework which will be enacted in Scotland. And then thirdly, to share and hopefully sort of lead into a broader discussion on what might be some of the wider relevance of this process underway in Scotland, not only at a UK level, but European and internationally. So let me begin with the first point then, and that is the context for this process to enact a new human rights framework for Scotland. As you might expect, there were many contributory factors, but I would like to highlight what I think were 3 key drivers. The first is we were taking stock of Scotland's human rights journey after 20 years of the Scotland Act and the Human Rights Act. And for those of you who are not familiar with what that means, very briefly, the Scotland Act of 1998 established the Scottish Parliament with significant legislative powers being devolved to it by the UK Westminster Parliament. And the Human Rights Act incorporated throughout the UK the European Convention on Human Rights. So those two pieces of legislation actually coincided in terms of their chronology. And we wanted to take stock in Scotland of what progress had been made, what further progress needed to be made 20 years following those pieces of legislation. More of that in a minute. The second driver, I think, then was Brexit, the referendum in 2016, which has resulted in the UK leaving the European Union. And the third driver, very contemporary, is the effect of COVID-19. But let me just say a few words by way of explanation about this stock-taking process that we undertook, looking at what the last 20 years of the human rights journey in Scotland had taught us. And, you know, like all lawyers, it's on the one hand and on the other hand. On the one hand, we took the view that considerable progress had been made, and that in Scotland over the past 20 years, there had developed an increased confidence in human rights and an increased internationalist outlook. I think a significant step in that 20 years journey had been the establishment in 2007 by the Scottish Parliament of Scotland's National Human Rights Institution, the Scottish Human Rights Commission. And the work of the Commission from the time of its creation both reflected and strengthened this positive trend in Scotland of an increased confidence in human rights and an increasingly internationalist outlook. For example, as a national human rights institution which had A status, that it was recognized by the UN system, it meant that we uniquely, for a Scottish organization, which of course is not a member state of the UN, but the Scottish Human Rights Commission uniquely enjoyed direct participation in the UN human rights system, including speaking rights at the Human Rights Council and before the treaty body committees. And this in effect provided Scotland with direct international engagement with the international human rights system. And London, in a sense, was no more a gatekeeper in that respect. Furthermore, the Scottish Human Rights Commission became quite influential early in its establishment internationally. And for example, was elected by its peers to become chair of the European Network of National Human Rights Institutions, and also vice chair of the Global Alliance of National Human Rights Institutions. And within Scotland, it also became influential by its advocacy for the incorporation of UN human rights treaties, which had been ratified by the UK, but not incorporated. And the Commission also promoted the merits and the relevance of a human rights-based approach, which increasingly became adopted really throughout civil society, across public bodies, and within the Scottish government itself. So in effect, Scotland began to get on the front foot in terms of human rights throughout this 20 years. So that's the sort of, on the one hand, the positive experience. On the other hand, there was also during this 20 years, the negative experience brought about by a decade of austerity following the financial crisis. And this experience revealed the inadequacy of the UK human rights framework in that it provided insufficient protection of economic and social rights. And by themselves, the Human Rights Act and the Equality Act were unable to protect people from the disproportionate and discriminatory cuts in public services. So both of these developments, the positive trend of increased confidence and internationalism, and the lessons of austerity and the inadequate protection of economic and social rights, both of these developments pointed towards the need of a strengthened human rights framework. Then we had Brexit, and that provided an impetus to this need of a new human rights framework. This was because Brexit has weakened the current human rights framework. It removed the guarantee of EU social protections, and it now imperils the future of continued protection provided by the European Convention on Human Rights and the Human Rights Act. And then COVID provided an urgency to this need of strengthened human rights framework. This has laid bare really the need for strengthened economic and social resilience through guaranteeing economic and social rights. It clearly has taught us about the need to effectively address the structural inequalities that were laid bare by the disproportionate impact of the pandemic on different sections of our community. And critically, it also brought to attention in a way that was very dramatic the need to address the underlying climate and environmental crisis, which had not only caused the pandemic and will cause future pandemics, but poses an existential threat to lives, livelihoods, and the way of life of us all. So it was in response to these developments that the National Task Force for Human Rights Leadership published its report in March. This followed extensive public engagement, including from those with lived experience of the denial of human rights. It brought UN expertise at quite a senior level into the process to share international best practice and experience with us. And we also benefited from having an academic advisory panel, which produced a number of very helpful briefing papers, and certainly not least the previously referred to report of the Bonavero Institute, which also enriched the thinking within the task force. The report included which rights we were recommending for the framework, which duties, and effective implementation measures. These recommendations were immediately accepted by the Scottish Government because it was a Scottish Government-led process, and I served as an independent co-chair, but my fellow co-chair was a cabinet secretary of the Scottish Government. However, it was not only a Scottish Government-led process, but the report received widespread cross-party support within the Scottish Parliament. We had engaged with all of the political parties throughout the process of about 18 months or so of public engagement and preparation of the report. And in the Scottish general election, which was held just earlier this month, support for the task force recommendations and the report could be found in the manifestos across the political parties and not only in the governing party. The outcome of the election, just to bring us up to date, was that the government was convincingly re-elected. Preparations are now therefore beginning to have public consultations and a public participatory process, which will support the drafting and the presentation of a bill which will be presented to the Scottish Parliament in this new session. There will then also, to accompany the bill, be a programme of capacity building, both of rights holders, civil society and public bodies, in order to enable the effective implementation of the new framework once it's enacted. So that's something of the context, and let me now move to the content of this new human rights framework. In terms of rights, I think probably the most striking thing about the framework will be that for Scotland, it will for the first time put in a single place the range of internationally recognised human rights, and not only civil and political, but economic, social, cultural, and environmental. And these rights, of course, belong to everyone. It will include and build upon the Human Rights Act, but will go much further. For example, it will include the incorporation of the International Covenant on Economic, Social, and Cultural Rights. And therefore, this will provide the right of everyone to an adequate standard of living, including the right to adequate food and to adequate housing, and to the continuous improvement of living conditions. It will include the right to the highest attainable standard of physical and mental health, the right to social security, to education, and to take part in cultural life. But going beyond that, in order to ensure that there is equal and full access to such rights, as well as help address the issue of intersectionality, the framework will also include the incorporation of other key human rights treaties from the UN system. So CEDAW, the Convention for the Elimination of All Forms of Discrimination Against Women, CERD, the Convention for the Elimination of All Forms of Racial Discrimination, and the Convention of the Rights of Persons with Disabilities will all be incorporated within the same bill. And in recognition of the climate crisis, the framework will include the right to a healthy environment. And additionally, not least because of the COVID impact, there will be a specific right of older people and also equality rights for LGBTI people. As regards the corresponding duties, there will be an initial duty for all public bodies to pay due regard to these rights and to ensure that they make preparations in line with that duty in terms of their policies, practices, procedures, and to prepare then for a sunrise clause, which will trigger, after a defined reasonable period, a further duty to comply for all public bodies. That is the provision of effective remedies should there be a failure to comply with the rights within the framework by any public body or private actors carrying out a public function. There will be strengthened access to justice, which will provide effective remedies such as structural interdicts, and also the standard of review, of judicial review, will be that of reasonableness as opposed to the existing Wednesbury doctrine within the UK. And this standard of reasonableness will be taken from international human rights law and practice and experience in other jurisdictions. In addition to the rights and duties, clearly, they will only stand or fall depending on how effectively they are implemented. And so there's a series of measures to provide for the effective implementation of the framework. And a variety of powers and duties will exist across Parliament, Scottish Government, public authorities, scrutiny bodies, as well as the Scottish Human Rights Commission. These will include pre-legislative impact assessments by the Scottish Parliament of all bills presented to the Parliament, not only to ensure that they are compatible with the rights in the framework, but that they also contribute to giving further effect to the rights within the framework. So part of the progressive realization of these fundamental rights. There will be a requirement on the Scottish Government to produce what we're currently referring to as a human rights scheme. That is a plan of implementation of the framework. So the government will have to provide and regularly update a scheme which demonstrates that they are going to bring forward specific legislation to give further effect to these foundational rights in the framework. The government will also have to demonstrate that they are taking the rights in the framework into account in the budgetary process. It would also have to demonstrate that it is developing a collaborative national human rights action plan in order to give further effect to the framework. And also it will have to report on how it is enabling the right of participation in many of these dimensions of the implementation of the framework. In respect of all public authorities, and including private actors carrying out public functions, they will be required to produce implementation plans and also to demonstrate how they are realizing the right of participation of the public and of individuals in the development of these plans. The scrutiny bodies, and by that we mean the inspectors, the regulators, the ombuds institutions, the auditors, what we refer to as the everyday accountability sector, they will also be given powers and duties that they should, through a human rights lens, carry out their monitoring role of public authorities delivering on the rights within the framework. The Scottish Human Rights Commission will be given increased powers that they can conduct inquiries into systemic concerns and also take test cases where that is the appropriate thing to do. So in other words, it will be a multi-institutional approach of progressive realization with access to justice and the right to effective remedy as a backstop, an essential backstop, but an attempt really to sort of front load the implementation of the framework through the scrutiny bodies and through various other forms of accountability across the institutions that I've mentioned. And monitoring of the outcomes will also be embedded into the framework's implementation. And all of this follows very much from the task force adoption at the outset of a human rights-based methodology of structure, process, and outcome. Structure being the commitments made within a legal and governance framework, so the rights and duties. Process being the efforts to implement those commitments, budgetary, legislative, administrative, etc. And outcomes is the monitoring, the measurement as to what extent are these rights actually being realized on the ground and being real in people's everyday lives. So the third point then, and maybe leading into the discussion, what might be the wider significance of this process beyond Scotland? And at a UK level, at a European and at an international level. Well, I think at a UK level, first of all, as pointed out by the former UN Special Rapporteur on Extreme Poverty and Human Rights, Professor Philip Alston, following his 2018 UK mission, he identified two contrasting trajectories in human rights within the UK. And to sort of crudely paraphrase his report, one of these trajectories is quite regressive and quite inward looking. And the other is quite progressive and outward looking. And I think subsequent development since Philip's mission to the UK in 2018 has confirmed this analysis. For example, we currently are seeing UK level reviews of the Human Rights Act and of judicial review on the one hand. And then we have this process underway in Scotland of steps to further strengthen a new human rights framework and an internationalist approach being taken towards doing that. In the short term, this may regrettably lead to certain political and constitutional tensions because these trajectories are, just what it says, they are different trajectories towards an attitude of realizing human rights. In the longer term, I would hope that Scotland will positively influence public debate in England and that a similar approach may in time be taken and strengthening social rights and increasing accountability, for example. And also we're already seeing significant interest in what's happening in Scotland from those in Wales and in Northern Ireland who are at different stages of the same sort of trajectory, contemplating, for example, a Bill of Rights in Northern Ireland and contemplating strengthening the human rights framework in Wales, where they've already begun, for example, with the UN Convention on the Rights of the Child. So it may be appropriate to sort of paraphrase Joe Biden, that Scotland can hopefully lead through the power of example, not the example of power, because Scotland has limited power, but hopefully through its example, whilst in the short term, it may not be one that's taken up by the UK government, but hopefully in the longer term. And once we see this framework beginning to actually improve people's lives, I think that is likely to influence public debate and an appetite in the rest of the UK that this approach should be taken seriously. At the European level, the current UN Special Rapporteur on Extreme Poverty and Human Rights, Professor Olivier de Schutter, has recently completed a mission to the EU and called for increased protection of social rights post-COVID, and an increased attention by the EU and member states to the UN Human Rights Treaty obligations, which are not as visible as they should be within the architecture and approach within the EU. So Scotland's trajectory clearly reflects that kind of recommended approach for the EU. And I think post-Brexit, Scotland's example can hopefully be expected to resonate in Europe and to be welcomed by many, as will its defense of the Human Rights Act and of the European Convention on Human Rights. So I am already sort of picking up an increased interest within Europe as to what's happening in Scotland because of the concern about Brexit and the implications of that, and to have something positive emerge from Brexit, I think will be welcomed and is already being looked at with interest across Europe. And then finally, on a broader international level, we all know that the UN Secretary General has called upon all countries to build back better and to place at the center of all post-COVID recovery efforts the strengthening of economic and social rights in particular, along with environmental rights. And again, this is the path that we are embarking on in Scotland. And while we're not a member state per se of the UN, again, what we are trying to do will hopefully resonate and have an increased profile, again, because of the concern about Brexit. And I think, and I know that what is happening in Scotland is being viewed in and around the UN system as being a welcome reaffirmation of multilateralism, of international cooperation and support for an international rules-based order, including not only the UN Human Rights Treaty system, which itself is under some pressure, but also the Sustainable Development Goals, which mutually reinforces the treaty system. Specifically, it's also noteworthy, I think, that in the new Scottish Government post-election setup, the responsibility for taking forward this bill to establish the framework has been given to the Deputy First Minister, who has specific responsibility for post-COVID recovery and the sort of just and fair and sustainable post-COVID recovery that is necessary. And so the bill is being positioned right at the center of government, at the center of recovery. And this does align very much with the call of the UN for all countries to do so. And then more specifically, there is a relevance, I think, in the inclusion within the framework of the right to a healthy environment. This has been welcomed by past and present UN special rapporteurs on the human rights and environment, because it contributes to growing support within the UN system that the UN itself should formally enshrine such a right in recognition of the climate crisis and the clear links between environment and human rights. And similarly, and again, quite specifically, the inclusion of a right of older people has been welcomed by the UN independent expert on the rights of older persons, Claudia Mailer, as supportive of the process to prepare a UN treaty on the rights of older persons. So to conclude, the process, which has been and will continue to be underpinned by public participation, is a genuine effort to provide human rights leadership in and by Scotland. We are, of course, a very small country, but we hope that our efforts do contribute to wider progress in what is an interdependent world. And I look forward to discussion for the rest of this presentation on that. And once again, I'd just like to thank the Bonavero Institute, not only for this event, but for their engagement with, their interest in and their support of this process underway in Scotland. And I look forward to that continued relationship. So with that.
Well, thanks, Alan. That was really clear and really a wonderful overview of this extraordinary process. So thank you very much for that. I'm now going to turn to Hayley for her comments.
Thanks very much to Kate, and a huge thanks to Alan as well. That is indeed a hard act to follow by every possible metric. I agree. I think it's absolutely commendable to see a devolved government taking a real evaluation of human rights obligations so seriously. And I agree that the distinction between the UK government's independent review of administrative law and independent review of the Human Rights Act is absolutely marked. And from the perspective of being down south, the UK government is kind of marked for all the wrong reasons. So the report has covered a lot of ground. Obviously, it's in depth. It's on the basis of widespread consultation. It makes a commitment to public education. And I can't possibly include all of the comments or questions that I would like to, but as a discussant, it is my duty or kind of intellectual responsibility to push back a little bit. So I'm going to focus on 5 areas of the report that I see as kind of maybe would welcome clarification on, or sort of instances of relative silence in the report. Just to point out as a placeholder, there's something in the report that says it's very interesting, and I think it's kind of emblematic of the report of kind of politics and bureaucracies first. It says the purpose of the protection is to protect and improve the lives of individuals and communities, so these rights should be experienced in their everyday lives, with access to court being a last resort. And although judicial review is a remedy of last resort in many senses, I think this nonetheless stood out for me. So I've very much gone through this report as a public lawyer, and my comments kind of flow from that disposition as a public lawyer. So I've got 5 areas of comment that I'm going to focus on, and they all kind of run into each other, but just to hold them out in the air, I've got some questions about legislative design, about intensity of review and questions of justiciability, about the concept of human dignity, about references to an interpretive clause, and then finally I want to say something about the way in which the report approaches existing obligations under the Human Rights Act and under general administrative law principles. So I'm just going to work through them in order with a view to hopefully stimulating more discussion, actually, is the kind of key goal here for me. So thinking about legislative and constitutional design, I absolutely agree that we should be moving towards, whether it be the UK as a whole or if Scotland decides to go its own way, the protection of all categories of rights, civil and political, social and economic and environmental. And I think that all categories impose positive duties on the state. I think the positive and negative duty is a false dichotomy. And for those of you who want to read further on this, I think it's best illustrated by Fredman's book, Human Rights Transformed. However, I still think there's an issue about order of magnitude in respect of these positive duties in different categories of rights. And I think there is definitely something to be said about the different order of magnitude of obligation that the protection of social and economic and environmental rights impose on public authorities. And I was quite interested that the report maybe did a lot of background research on, but didn't engage directly with this issue, because I think it must have some implications for legislative design. It certainly has done in the context of Ireland, South Africa, India, and much more ambiguously so in the EU Charter of Fundamental Rights, which refers to rights and principles but doesn't tell you which is which, unfortunately. So I think it's interesting that the report doesn't take this step, maybe for very good reason, but I would nonetheless like to hear more about it. Continuing as a lawyer, my second sort of area of inquiry is about intensity of judicial review or justiciability. And one thing, perhaps because of the kind of public authorities' first focus of this report, is there's no reference to justiciability, even although there are significant references to the role of the courts in this report. I wondered if that was a deliberate choice, or if the idea of questions and competence of justiciability or justiciability were simply not on the agenda when the report was written, because it remains a significant live issue in, as far as I can see, all levels of human rights adjudication for a variety of different reasons. And this kind of feeds into my question about the intensity of judicial review. I thought it was very interesting that the report wanted, or kind of purported to say, that the statute should specify the intensity of review. I was part of a group responding to the independent review of administrative law held by the UK government, and we came out very strongly against any kind of codification or specification of statutory standards of either grounds of review or indeed of intensities of review, because it is actually one area where you could compromise, in theory, the independence of the courts, and it could lead to as much backsliding as it could to progression in the wrong political climate. We can't guarantee that Scottish politics is going to be this rights positive as it is at the moment for the long term. So I think it's something worth having a little bit of a concern about. My other concern was that obviously it's well known to those of us who work in the UK, and if you're tuning in internationally, the standard of review of the Human Rights Act 1998, which is set by the courts in cooperation with the jurisprudence of the European Court of Human Rights, is proportionality. And that appears nowhere in this report. And I wonder if that was a deliberate choice, if there's something to be said about international rationality as it's described in the report that's more functional or better. And I would welcome more discussion on that, particularly from Professor Miller or for any of the others who are experts out there listening in on the webinar. It's with great trepidation that I move on to comments about human dignity in the presence of so many experts. But I did think it was interesting about the idea of specifying human dignity, perhaps even in an interpretive clause in the statutory framework. Obviously, most international human rights treaties have a reference to human dignity, and I think it's important to note also that the European Court of Human Rights has kind of developed this in its corpus of interpretive principles that the Strasbourg Court has developed across time. But, you know, in major works, for example, by Professor McCrudden, it's been questioned in terms of its usefulness as an interpretive heuristic, because it does have the kind of ability to mean all things to all parties. He points out, for example, that it can be a major constraint on some rights if deployed by the state in the context of, say, anti-terrorism litigation. And in other cases, he points out that dignity claims have the effect of elevating one side's reasoning to the status of a trump card, which obscures more forensic legal analysis in some cases. So I thought that was worth putting out as a placeholder there, that there is some scepticism towards the concept, at least academically, that the report doesn't seem to address, or maybe it was just swayed over by the overwhelming amount of evidence that suggests that this is the way to go by the more in-depth research. My next concern is about the idea of an interpretive clause in the statute, which is recommendation 10 in the report, which says that any framework should provide that courts and tribunals are clear on the intent of legislation, including the underpinning value of human dignity in relation to international law and comparative law. It's suggested this could be done through an interpretive clause. And I looked at the UN Convention on the Rights of the Child bill currently going through Parliament. It has such a clause, which seems kind of benign and sensible in many ways. It says, so far as possible to do so, the legislation mentioned in subsection 2 must be given and read and given in a way that's compatible with UNCRC requirements. Obviously, we have an interpretive clause in section 3 of the HRA asking courts to take into account. But when I reflected this insofar as possible to interpret compatibly with convention rights, but when I reflected on the enormity of the task that's going to be set for public authorities and courts in terms of looking at international jurisprudence and comparative jurisprudence, concepts like the minimum core and progressive realisation, I was wondering if perhaps maybe a take into account duty would provide a more important or more kind of, how can I put it, appropriate form of judicial latitude in the way that section 2 of the HRA has done. So I'm wondering at this stage, because there's no draft clause, and that's quite proper for a report of this nature, it's a high level policy document, should we have a take into account duty, or should we have an insofar as possible interpret compatibly duty when it comes to international and comparative duties? And then finally, this is my last set of comments, is that, or this is my penultimate set of comments, isn't it terrible when a speaker does that? I do kind of have some doubts as to how the report kind of rationalises and treats existing Human Rights Act and administrative law principles, and in particular the way it conceptualises the standard of Wednesbury unreasonableness in domestic administrative law. It doesn't spend a lot of time unpacking this because of the nature of the enterprise that it's engaging in. that Professor Miller set out so clearly. But I think it's important to note that rationality review by courts applying domestic administrative law principles has come a long, long way since the days of the Wednesbury case in 1947. And I wanted to point our listeners to two recent Court of Appeal cases decided in 2020 in England and Wales that actually use domestic administrative law principles to vindicate social and economic rights and the types of international obligations that we've been looking at, maybe not in explicit rights terms, but certainly covering the same subject matter. So in the Johnson case, the Department of Work and Pensions' refusal to alter an algorithm for allocating universal credit top-ups to those on low salaries, and this algorithm was faulty. It was causing financial chaos for the families and recipients who desperately needed this income. And before the Court of Appeal, the government department's case was that it would simply be too much time and financial hassle to alter the algorithm. Using the standard of Wednesbury unreasonableness or rationality, the court conducted a forensic dissection of the evidence and held that position to the Department of Work and Pensions to be unlawful. So I think that's quite an important example. And there are many more of how you can use domestic administrative law principles to speak to these types of issues whilst ensuring enough policy flexibility. My second example is the Article 39 case. It's a case about COVID-19 and the provision of children's services. The relevant government department tried to make all kinds of alterations to secondary legislation, providing for the rights of children in care and adoption processes on the basis that these needed to be speeded up and altered because of the pandemic. In doing so, they claimed that they'd taken the UN Convention rights of the child obligations into account in making these decisions. But the big bad that they had committed was they did not consult the Children's Commissioner per their statutory duty, and the court undertakes quite a forensic discussion of the principles of administrative law and holds that not only is the failure to consult unlawful, but the alteration of the statutory duties are unlawful as a result. And finally, my final comment is that in terms of what strikes me overall about this project, and especially in relation to COVID-19 and the UN's commitment to build back better, is that what we really need is three things, perhaps four. We need monetary investment, we need policy flexibility for public authorities, and we need to really appreciate how the existing human rights and administrative law framework can assist in achieving those aims. That's not to say that we don't need the international commitments on top, but I think it's important to weigh in the balance, particularly with respect to the HRA's commitment to a standard of proportionality. So I will wind up there so that we have the maximum time of half an hour for a discussion. Thank you for listening.
Thanks very much indeed, Hayley. I'm going to give Alan a chance to respond to those really interesting points and just encourage people who are attending to add to the Q&A, which we'll turn to in a moment. Alan.
Yeah, thanks, Kate, and thanks, Hayley. These are very well-made points, and I don't want to take up too much of the question and answer time to respond to them, but maybe just make a couple of sort of overall responses to what you were saying, Hayley. That I think, first of all, the basis of the report in terms of the evidence base really came from widespread public engagement and the experience of rights holders, those with lived experience of being frustrated in their enjoyment of human rights, particularly economic and social rights. Evidence base also came from roundtables where we brought together, to use the jargon, rights holders and duty bearers together to understand each other's experiences of the human rights framework to date, its strengths and its weaknesses. And then we did have a number of academic papers which are, linked, referenced in the report. And all of this was to inform quite high level policy objectives for those who would then go on to draft the bill, the government. So we denied ourselves what would have been an enjoyable pursuit of exploring in more depth some of these questions you've raised, but That wasn't really the mandate that we were given. Having said that, some of the issues that you raise, and this is the sort of second overall response I think I'd have, so the issues of justiciability, of the economic social rights, the standard of review, the interpretative clause, the question of human dignity, several of the recommendations did very clearly say that further collaborative work will need to be done to further develop how those areas should be operationalized, not so much only in the bill and the provisions of the bill, but in the accompanying statutory and non-statutory guidance, capacity building, public education, development of training and best practice, and not least in access to justice. You know, we had 18 months to do this report in the midst of the pandemic, and the reach of our engagement, we recognized had to go further, particularly into the access to justice sphere, and therefore much more practical engagement with teasing out what should be the policy objectives that were in the report. So, and that will come, that the next steps in this process will be a bill team has been established to begin the process of drafting the bill. Further public consultation and engagements will be carried out. And then there will be a reconfiguration of the task force in one form or another, some kind of advisory, collaborative process that will dig deeper into some of these areas in order to flesh out some of the policy objectives that were in the recommendations. So more to come, and we'll keep you informed, Haley, and hope that you can be part of that as we go.
Yeah, absolutely, and thanks very much. Yeah, absolutely. It's perhaps my questions were more geared towards the next step, because this is, as you say, it's a freestanding achievement in itself, this report. But yeah, lots of hard and interesting questions on the road ahead for sure.
Great. Well, thanks very much, Alan. Thanks, Haley. You know, we'll obviously keep an eye on this process as it develops. So one of the questions that's come in, Alan, from Robert Freeman, who you remember supported Manuel and Martin and I when we were working on the document for the task force, relates to the inclusion of the idea of pre-legislative assessments of legislation. And he'd like to hear a kind of some more detail about that. Is it going to be modelled on the kind of scrutiny in Parliament that we see already by the Joint Committee on Human Rights, for example, in the UK Parliament, or do you see it working somewhat differently?
Yeah, thanks, Robert, and thanks for your earlier work as well. Where we got to with pre-legislative assessments were recognising the importance of them as being a fundamental part of the Parliament holding the government to account for the implementation of the framework. And we looked at the experience of the present means of pre-legislative assessment of the Human Rights Act and European Convention human rights, and how that would have to be further developed to be aligned with this new framework. So we actually looked at the Finnish experience, which was quite interesting, of the committee within the Finnish Parliament and the role that it played in pre-legislative assessment and the status that was given to its reports. And the Scottish Parliament itself had recently undertaken a study as to how it could better perform as a guarantor of human rights and better hold the government to account. So we were trying to bring together several things, and we saw the need of an enhanced role for a Human Rights Committee within the Scottish Parliament. We had a member of our task force who was a former legal advisor to the Joint Committee at Westminster as well. So we benefited from that. And we saw that the enhanced role of pre-legislative assessment should be clearly that it had to go well beyond compatibility with the European Convention on Human Rights. It now had to be compatible with the different treaty obligations from the UN system and the other rights within the framework. So economic, social, cultural, and environmental rights, a much broader sweep to be included in the pre-legislative assessment. we thought that in preparing the pre-legislative assessment, there should be scope for as much collaborative process and participation from the public, from civil society, from independent experts, in order that the committee's status and authority was enhanced by the pre-legislative assessment being carried out. We also thought that the requirements of those presenting a bill, the government, in saying whether or not it considered it was meeting the requirements of its human rights obligations, should be much more transparent than at present. It should be more than just a statement saying that we consider it, we are compatible. And it should provide some of the reasoning and some of the factors and the weight that was given to different lines of argument in the preparation of a bill. So both its scope, its depth, and the breadth of participation in the deliberations of the committee. And it shouldn't just be also on a kind of negative impact assessment. You know, will this breach, or is this compatible or incompatible with the obligations, but more proactive. To what extent will this serve the progressive realization of these rights within the framework? Is there an opportunity here that is not being taken, that should be taken? So a more positive, proactive approach taken to the impact of the legislation that is being assessed.
Well, thank you. And then the next question is from Martin Scheinen, and it's, you know, he starts out by noting that recommendation 1B suggests that the International Covenant on Economic, Social and Cultural Rights be incorporated into Scots law. And then he turns to looking at principle or recommendation 13, in which the question of how the minimum content of each right should be determined for, so to guide civil servants so that people should know about it. And policy objective 13 states that basically there should be a process of public participation to determine the minimum core of the right for Scotland, which should of course take into account international law obligations and international principles governing minimum core, but that actually would be determined by public participation. I mean, could you talk about that a little bit more, given how crucial this is to the protection and fulfillment of economic, social and cultural rights?
Yes, thanks, Martin. I was very apprehensive about when I saw your name on the list of participants, and I anticipated that there would be very searching questions, and we would want to continue this conversation with you, Martin, and others and reach out to you for support in this. The report reached a certain stage by simply saying that there has to be a process to define minimum core standards within the Scottish context. And that shouldn't solely be a technical, legalistic exercise, but it did have to embrace the reality of people's lived experience and the different contributory factors that contributed to the enjoyment or not of an adequate standard of living. So across the range of income, social security, housing, food, delivery of public services, transport, and it plays in different parts of the country, rural, urban, island, etc. One of the contributors to the task force process was a group of rights holders called the Adequate Standard of Living group, which is made up of rights holders who were very good in keeping our feet on the ground and saying, you know, we're the ones that know what an adequate standard of living is. We're the ones that know what it is to live a life of dignity or not. And therefore, that evidence has to be included in part of the process of defining what are the minimum core standards. And we completely adopted that, and that must be part of it. So we're now at the stage where we're beginning to have this conversation as to where in the process of drafting and passing the bill and then giving subsequent legislative effect to it through specific pieces of primary legislation and budgetary decisions and all of that, at what stage in the process overall should this defining the core standards be? How should it be designed? Who should be involved? What should be the criteria? What should be the international best practice that we could learn from? So it's very much a next step, which we simply in the report identified as being necessary, and that it should include the element of public participation. But we really will be, and I'm not joking, we'll be reaching out to you, Martin, and anyone else that will give us the time of day to get advice as to how best to take this forward.
So Martin's other point, Alan, is whether there is a role here for looking to the European Social Charter, which obviously has traverses the same ground and in some cases in more detail than the International Covenant. And, you know, obviously with Brexit, that's a slightly more complicated thing to do than it might have been before it. But any thoughts on that?
Yes. I mean, because the UK hadn't ratified or hadn't adopted the revised social charter, it doesn't have a lot of resonance within the UK. And obviously, as you've said, Kate, even less so now since Brexit. But what we have put in our recommendations for this human rights scheme that we say the government should present to Parliament its plan for how it's going to give effect to this framework, legislatively, budgetary, administratively. Part of that human rights scheme is that we want the government, and there might be a need for a national mechanism for monitoring, reporting, implementation, but a mechanism that will track progressive developments, not only within the European Union in terms of the Charter, but Council of Europe more widely, so that Scotland will not fall behind progressive developments, that it can take, for example, from the European Social Charter. It might be specific provisions on the right of older people, for example, in housing and social security. And whilst Brexit prevents the Scottish Parliament from ratifying by itself the European Social Charter, there's nothing to prevent the Scottish Parliament and government looking at specific relevant components of the Charter, how they're being applied and interpreted elsewhere within Europe, and then giving effect to that within our devolved areas of competence through legislation or whatever means is the most appropriate. In order that we don't get left behind, we can keep pace with these developments, but also go beyond. And you know, by having a broader sweep of the international human rights obligations, which in some respects in the UN treaties go beyond that within the European framework, then we want to have that breadth of scope and for the Scottish Parliament and government to be sharing the duty of ensuring that attention is given to the likes of the European Social Charter and what is appropriate to take from it and put into Scots law and practice should be part of the obligation on the government and the Parliament to have that as part of its human rights scheme.
Well, thank you, Alan. I wonder if I could put a question to you, which is that, and which perhaps might give people who are listening some sort of more detailed understanding of what's thought through here. When you were working on this, you must have had circumstances in your mind that you think will be affected by this new legislation. I mean, it's a little bit like the old mischief test for statutory interpretation. What do you think is that this legislation that you envisage will be drafted and adopted as a result of this report? What do you think that will do to make a real difference on the ground? Can you give us a couple of examples of the way things are done now that you think may result in being done differently, or even just one being done differently once the report is duly drafted into legislation and enacted?
Yes, I had there was a kind of roundtable organized a few weeks ago by those involved in housing, and this is what's happening in different sectors in the country. People are looking at this framework and trying to figure out just that. What are the implications for either the services that we deliver or from a rights holder's point of view, the frustrations they have about not being able to have the dignified life that they think that they're now going to be entitled to. And so this was a roundtable looking at housing, and there was the local authorities there was housing associations, there were private sector landlords, and there were tenants associations. And really, what the task force is saying is that, we're not attempting to be prescriptive and say, this practically is what is going to be the outcomes of this framework, other than in general terms. But what came out of that discussion when those who were more expert in housing began to pore over it was, I think it will lead to, for example, there are problems with homelessness. There's simply not enough housing of affordable or accessible types, and homelessness remains a problem. There are problems about the quality of housing, particularly in the private sector, but not only in the private sector. And I think, therefore, that we will see an increased accountability of duty bearers to provide the right to adequate housing. And that will result in it being given more political prioritization and more budgetary prioritization in terms of the increase of housing available and the standard and quality of that housing. And I think that'd be one example where, if that wasn't done and these systemic problems remained, then under the implementation measures of the framework, the burden would not fall on each tenant to bring forward a claim that the housing standards were below a threshold, or that there was simply inadequate access to housing. But you could have, for example, the Scottish Human Rights Commission or a housing NGO could bring a case saying there's something systemically wrong with the right to adequate housing not being implemented. And that would reach the housing regulator, the sort of monitors and inspectors. But if they were not able to remedy that, and it really was a budgetary and a political priority that had to be made, then it could come to the courts, who would look to see whether there was a systemic breach of this right to adequate housing. And therefore, a structural interdict is this innovative remedy, or innovative for Scotland. We're recommending that the courts would be able to say, this is not compatible with the right to adequate housing, and put it back to the duty bearers to come up with a plan as to how they were going to overall remedy the shortcomings in the realization of the right to adequate housing, and for the court to come to a view as to whether that plan was a reasonable one in terms of its composition, the timeline, the resources, etc. So that's certainly one example that has come up in the last few weeks, when those who weren't involved in the process itself are now beginning to explore what are the implications.
Well, thank you. I mean, perhaps one last question for me, because we had the conversation before we started, which was the fact that in the recent Scottish elections, that this was not considered, that the report of the task force was not considered to be divisive or controversial in any way, which as Hayley mentioned, with in the UK, where there's currently ongoing an independent review, not only of administrative review, but also of the Human Rights Act, that strikes one as somewhat surprising. Would you want to speculate on why that may be? Why in Scotland there seems to be that what is a very ambitious and in many ways innovative way of thinking about human rights is not creating political division, but seems to be quite warmly kind of accepted, and there is a sense that it should be pursued. Why do you think that is? I mean, what do you pin that on?
I think it's the political culture, but not only the political culture, the public culture. If like Hayley was saying earlier on, for example, she was quite understandably questioning sort of emphasis we have given to human dignity as being the underpinning value of the framework. One of the reasons we did that is human dignity resonates very deeply in the Scottish psyche for many, many, many years. And people get it. And not only do they get it, but they understand it in their own everyday experience. And if they don't get it, they don't think it's fair. And when they don't think it's fair, they want something done about it. And so that very deep-rooted public culture has produced a political culture where, even though there may be, and there certainly are, a lot of tension in Scotland about for the union or for independence, that is the fault line that runs through Scottish political life just now. But you dig a bit deeper and you look at the manifesto commitments, the social commitments of all of the political parties in Scotland, and they all have to go back to that public culture and expectation if they're going to win any votes. And so there's not a lot of difference between, in terms of social and economic approaches of most of the parties. I mean, the Conservative Party would probably be a bit, well, it is a bit different, but even in Scotland, it's not the Conservative Party that there is in power in the UK. And so I think also because we're a small country and wanting to build a better country, and again, that's not party political, there's a much more meaningful interest in looking at the rest of the world and learning from the rest of the world and not thinking we're better or we're exceptionalist, but being quite modest, saying, you know, other people are facing these problems. Let's understand how they're tackling them and take away the best of that. And also a certain responsibility of contributing to solving problems globally, even though a very small country. And all of that sort of deep-rooted human dignity sense and internationalism, that's what I was saying, the 20 years of devolution has allowed the Scottish Parliament to express that and manifest it in a way that wasn't possible before we had the Parliament. And so we have seen that sort of standing up, looking around the world and saying, we want to be part of this and contribute to it. And where we can demonstrate leadership, we've got that ambition.
I mean, very interesting, because when, you know, often thinking about problems as a constitutional lawyer or comparative constitutional or human rights lawyer, you come back to the question of political culture, of legal culture, and how one creates those and how fosters the kinds of legal cultures. And it's interesting, one of the things you point to there is devolution itself as having created a sort of sense of almost agency in the political community in Scotland. So that's really very interesting. Hayley, we've talked a lot to Alan. Are there things you'd like to say before we finish, or comments that you got on any of the questions?
I suppose it's interesting. I have quite a different view of political culture in Scotland, I think, than Alan, and I think there's room for healthy and reasonable disagreement. I did have one question about working on the ground, actually. Like, I think that was a brilliant question. I can't remember who asked it. I'm sorry. Was, you know, what difference will it make on the ground? And particularly with the constitutional commitment to access to justice, which exists anyway, but I was really pleased to see a doubling down of that in the report. But I wonder, do we envisage doing anything to combat systemic legal aid cuts, which have been a problem both south of and north of the border? That seems to me that if you want to get anything, if any political party wants to get anything off the ground vis-a-vis this initiative, then it really has to be about you know, making sure that the money's going to the right places. And there's been kind of ample opportunities to do that already, and it hasn't been done. So I guess my question as a lawyer is what will this doubling down of the commitment add to the party in the long term?
Yeah, I think access to justice, you know, has many features to it. Not only literally the access to justice through legal aid, etc. What comes out at the other end? You know, how do the courts look at a claim, and what orders do they make in terms of remedies? But the question that came up a lot in the public engagement for this process was the need for independent advocacy. Now, whether in all cases that would require legal aid and legal advice and representation in court, or whether it also simply meant independent advocacy that could empower and support an individual or community in their dealings with authorities and come to an outcome that didn't require you to go to court and to obtain legal aid and legal remedy. But it certainly is an issue, and it was also one of the reasons why we said that, for example, the Scottish Human Rights Commission should be vested with powers to take test cases where there are clearly systemic violations of human rights.
I think that's absolutely correct, but I would definitely suggest that the issue is much bigger than human rights claims per se and inherently. And I think if you were to ask the broader public, what does access to justice mean to you, the paradigm would be courts and legal aid. I suppose my final question actually is about remedies. So I like the idea of a novel remedy, the interdict that you spoke about. But I was also quite intrigued that there was no explicit discussion, as far as I remember, about suspended remedies, which might actually have to be an issue if you're to effect appropriate structural change in a bureaucracy. And the other thing that concerned me, in what is obviously post-COVID and post-Brexit, is going to be a kind of a resource-strapped culture. Even a very well-intentioned political culture is going to be resource-strapped. So I was quite surprised to see that damages were kind of front and center on the agenda for remedies, particularly when, you know, they would be a drain on the public purse. And there is a lot of evidence to suggest out there, at least from the Strasbourg court, that damages don't have the effect of kind of nudging cultural change in the right way. So I was wondering if you could reflect a little bit more on that, please. And that's me.
Yeah, I mean, in terms of suspended orders, you know, that would be something that was inherent in the structural interdict that we have recommended. So that would be one order that we hope will be taken forward. In terms of I agree with you that legal aid, I don't think there's a country on this planet that has an adequate legal aid system, that they all need strengthened. And that, I think there is more opportunity of doing that as part of this momentum and understanding, you know, maximum available resources for the progressive realization. So I think we will see a reprioritization of these kinds of questions. But, you know, we're all realistic. Post-COVID, there is going to be limitations on resources. And it will come down to political priorities, maximum available resources, progressive realization. Scotland is a developed country. It does have significant resources that can be allocated towards the implementation of this framework, but it's setting a direction of travel. It's setting a path and the criteria by which decisions need to be and will be made once this framework is applied. But will it be a panacea and that will, you know, in 5 years' time, you'll never hear anyone say there's not enough in the legal aid budget? I doubt that.
No, I doubt it as well, but I think it's something worth considering. I hope you're right. I hope it does catalyse a direction of travel, because that would be excellent.
Great. Well, thanks very much to Alan and to Hayley for a really interesting presentation and conversation about a very encouraging new development in Scotland, which we will definitely watch with great interest. And thanks to all of you who've been here and for your interesting questions. Just to remind you that the last discussion group for this term will take place next Tuesday, and we will have Dr. Agnes Kallamar, the new Secretary General of Amnesty International and the former Special Rapporteur on extrajudicial summary and arbitrary killings, who will be talking about her report, and I'm afraid it's back to the depressing next week, on the killing of Jamal Khashoggi. And she will be, the discussant there who will be responding to her presentation will be Peter Edelyi, who's an independent investigative journalist in Hungary and the editor of one of the last remaining independent media outlets in Hungary, the 444.hu. So that will be again next week at 12:30. And so please do join us for that. There are a range of other events on during the week, so please have a look at our website to catch those, including a range of interesting book launches. So please join us for those. Final thanks again, Alan and Hayley. Great to see you. And thanks to everybody who's joined us.
Thank you.
Bye now.